forcing your judgment. You have to take legal steps to collect the judgment. The court will not collect it for you, and you may not take any action for 30 days from the date the clerk mailed the notice of entry of judgment, SC 130, to the parties. And during that 30-day period, the judgment debtor may do one of the following: pay you in full or request to make payments to you or the court, appeal the decision if they appeared at the trial, file a motion to vacate the judgment if they did not appear at trial, complete and mail you a judgment debtor satisfaction of assets, SC 133, and if the judgment debtor takes no action, below are the legal steps that you may take to collect your judgment in order so that you can collect. Number one is try to get in touch with the judgment debtor, and I would send them a letter requesting payment. You could levy or seize their assets that you have personal knowledge of or are listed on the judgment debtor statement of asset form. You could examine the judgment debtor in court to locate unknown assets, and this is one of my favorite techniques to get information on the debtor. Not only am I subpoenaing the debtor's financial information, I'm subpoenaing their landlord or their property manager if they're renting, because I want a copy of the rental application paperwork, which could include copies of checks paid to the landlord, and it might list where they work, so I could do a wage garnishment. Or if the judgment debtor owns a home, I'm subpoenaing the mortgage company, asking for a copy of the loan application and all documents relating to the judgment debtor's payments. I found a bank account on one of my judgments collection cases using this method, and I did a bank levy and collected $2,300. You could also suspend the judgment debtor's driver's license if they're involved in an auto accident. You could suspend the judgment debtor's personal license, like a contractor's license. You can place a lien on their land, building, or residence.